It's asking me to log back into Facebook. So I've done that. Okay. Okay. Okay, so I think it's actually okay. So we might as well begin. What I'm going to do is turn everything on. So I'm just going to turn everything on. And I'm going to start recording.
11.
All right. Mute. And oops. Chat. So I'm just right. Enable waiting room. So I've disabled the waiting room. All right. So to those who may be joining us live and to those who are watching this video because it is being recorded, welcome to HTJ.tax, where we talk about all things international tax. We try to demystify the sometimes confusing world of cross-border compliance and tax planning. If you've not joined us before, you can have a look at htj.tax/events because we do these live streams almost every week. And we try to publish a video every day on YouTube as well as wherever you'd find your favorite podcast. So whichever podcast platform you use, chances are we publish there as well. We have over 2,000 videos on our YouTube channel. We have over 1,000 videos, sorry, and over 2,000 articles on our website, htj.tax. So today we have the honor and privilege of having another conversation with the illustrious barrister, Mikhail Charles. Mikhail, please introduce yourself to those who may not already know you. You'd have to unmute yourself because you're on mute.
Darren, thank you. And good morning, good evening, wherever you are. And to all our followers, I do know that whenever we speak about matters Caribbean, offshore / UK, there are usually a flurry of questions, and I hope that we can get the discussion kicked off. So my name is Mikhail Charles. I'm a barrister practicing out of 3 Bolt Court chambers in the jurisdiction of England and Wales, but I'm also admitted and practicing in most of the Eastern Caribbean, and that's defined as 9 member states and territories. I am admitted in and practicing in Grenada, St. Vincent and the Grenadines, St. Lucia, St. Kitts and Nevis, also known as St. Christopher and Nevis, and the British Virgin Islands. I also am associated with a firm, a leading firm in Antigua and Barbuda, as well as the Turks and Caicos Islands, and some sole practitioners out of the Cayman Islands. All of that to say is that I'm interested in solutions, which is why I continually hang out and do some great work with HTJ.tax. Today, we were speaking, the topic for today is the treatment of crypto or NFTs, or as we would term it, crypto assets across the Eastern Caribbean and the Cayman Islands. But I think first, to sort of set the temperature or set the tone for today, we need to understand why crypto assets, what they are, why they're important in society, and how they're currently being treated, or the regulatory responses. So I think over the past 3 years or so, crypto has further exploded. I mean, thinking back to June 2020, there were well over 5,500 types of crypto assets, and more than 270 crypto asset exchanges available online. Now, in almost a Faustian way, the amount of crypto assets double or change almost every year. And this is us going back as far as January 2008 with the launch of Bitcoin. And they are the most popular type of crypto out there. And they do hold, and Bitcoin holding majority of global market shares. But why regulate? And when we talk about regulation, what does that mean? Now, because digital assets are increasingly important in modern society, they're used for an expanding variety of purposes. And that could be payment, to be represent or to be linked to other rights or things, something like crypto electronic signatures, cryptography, smart contracts, distributed ledgers, and associated technology. They've broadened the way that digital assets can be created, accessed, and used. Now, the clash between digital assets and the law comes in how it is to be treated. Is it property? Is it not? Is it something else? And I think that's the strength of the Caribbean or the Commonwealth Caribbean jurisdictions that base their legal systems on English law, because it has been held to be property, or at least to have the indicia or features of property. Just rounding that thought off, the Law Commission let me get my dates correct, the Law Commission earlier last year, but keep forgetting in 2023, the Law Commission earlier in 2022, in July of 2022, they put out a digital assets consultation paper, and that paper built on the work of the UK Judicial Task Force, which put out a very influential statement as to the status of crypto assets. Now, why regulate? Now, the need for regulation is based on the use of crypto assets to transfer value. And one of the old illustrations of how to launder money using gold is you have a piece of gold, you say it's valued like $1, but then you take it to another jurisdiction and really cash out $100. I know that's a very broad example, but it's something similar to that. Crypto is worth as much as it's worth because of the people who ascribe value to it. And because that value can fluctuate in a volatile way, because it's decentralized, there's so much potential for misuse and for very real financial and other types of harm to be inflicted on companies and individuals. The failure of crypto assets and criminal prosecutions surrounding FTX, which I think has been the most prolific thing to happen in the past maybe 6 weeks or so to crypto, reinforces the need for active regulation. Now, FTX is an Antiguan company that is regulated in the Bahamas, but its liquidation is being administered in the US. So immediately you see at least 3 jurisdictions. And when you look at the court filings, there are well over 100 different companies associated with FTX spread across the world. So FTX, Mt. Gox.
Sorry, yep, that's an important, obviously that is a really high profile scenario. I mean, it's not the first one, but perhaps the company that in the crypto space that has had the most far-reaching impact in terms of the number of people that have been inconvenienced in some way, shape, or form, or impacted, right? But the thing is that the Caribbean, as you pointed out, started down the road towards regulation even before that. So yes. My question is, so was there a particular incident that triggered this desire to regulate? Why not just leave it as is?
I think looking back to the context of AML, CFT, so anti-money laundering, countering the financing of terrorism, regulatory issues surrounding the offshore space, stretching back into the late 1990s, and that round of blacklisting from the OECD. OECD spilling over to FATF, spilling over to the EU, but coming back to the FATF in particular. Now, the FATF started recognizing the potential for the misuse of crypto assets with the use of offshore structures. And I think they sort of use the tax transparency initiatives to sort of springboard the need for regulation onto Caribbean governments. So there's an FATF recommendation 15 out of a report that they did on crypto, which suggests that regulation, or at least regulation by registration, should be mandated in Caribbean countries that are popular offshore centers, whose structures are used in the crypto space. So I think that was the impetus, and it only came to the fore maybe about 2018 or so, and then we start seeing legislative responses in the Cayman Islands in 2020. With their Cayman Virtual Asset Service Providers Act, which gives a framework for the registration of virtual asset service providers, and it also makes a series of consequential amendments to the anti-money laundering and countering of the financing of terrorism legislation to provide a comprehensive framework for the registration of virtual asset service providers, the types of crypto assets or virtual assets, and they use the term virtual assets very broadly because of the different types of crypto assets that can be deployed as a result of that. So just stepping back to the FATF guidance for a little bit. Now, the name of that publication, or the name of that set of guidance, was the Guidance for a Risk-Based Approach to Virtual Assets and Virtual Asset Service Providers, and that's recommendation 15. So under the rubric New Technologies, and it deals with the international standards on combating money laundering and the financing of terrorism and proliferation. So that recommendation, as well as the FATF guidance, was heavily pushed across the offshore world. And as a result of that, as we stated before, 2020, you see Cayman bringing in their law. Then we see the Eastern Caribbean Central Bank, or the ECCB, commissioning a consultant to make draft regulation or draft legislation called the Virtual Assets Act, which is very similar, if not materially identical in most part, to the Cayman Act. And that purports to be a model piece of legislation across the 7 member states of the Eastern Caribbean Currency Union. So you're talking from Anguilla in the north, even though it's an overseas territory of Britain, to Grenada in the south. But what we see is the politically independent states, member states of the ECCB, passing those laws and bringing those laws into effect. So we see Grenada passing it in 2021, St. Vincent passing it in 2022, Antigua passing it in 2020, I believe, St. Kitts and Nevis in 2021 and bringing it into effect more, or commencing that law more or less immediately. They're now into their second amendment, I believe.
So if I'm following you correctly, Cayman was the leader. They were the first jurisdiction in the Caribbean to come out with something of some sort of.
Yes. And interestingly, BVI has not yet passed a primary piece of legislation. They've circulated a draft bill, which I can share on screen if desired. They've circulated a draft bill for consultation to industry. But what they've done as a stopgap measure is amended their anti-money laundering law as at December of last year. So December 2022, they've amended the anti-money laundering law, making any virtual asset service provider, they will need to maintain client identification procedures, keeping KYC, suspicious transactions. They need to have internal reporting procedures for suspicious transactions, the usual suite of things that a financial entity would have to do. But most interestingly is that in the BVI, as at December of 2022, any virtual asset service provider will be required to comply with the travel rule. And the travel rule means that any transfer, so the originating and beneficiary virtual asset service providers, you need to obtain, verify, and maintain complete information on that particular transfer. And intermediaries, you also have obligations to do that, to show inflow, outflow.
Okay, but does it also include like audit requirements? So, for example, the firm needs to be audited by a recognized practitioner, anything like that?
Not explicitly, but generally. So when I say generally, because you're under an obligation to maintain accurate accounting records for a minimum of 7 years or so, your registered agent would be under duty to ensure that they have either with them a complete set of records, or at your registered office or at your place of business, or even in electronic format, a complete set of accounts, which can be inspected by the local equivalent of the Financial Intelligence Unit or the offshore regulator. So in any event, that I think brings you within scope to be inspected at the very least.
Well, okay, so in 2018, 2019, 2020, when these the regulators in the various jurisdictions were having a look at this, everything was theoretical, right? So I guess they were looking at what's going on in the UK, or perhaps to a less extent US or whatever, and the discussions happening there. They got in their consultants, as you said, and they drafted what they hope to be some sort of regulatory framework, but everything was theoretical. Now suddenly, as at the end of 2022, and as we having this conversation in early 2023, is no longer theoretical, is real. And if we were to look at what happened in the Bahamas, I know we're not discussing the Bahamas, but it's obviously it's within sphere being in the Caribbean. And if we were to transpose it and to say that FTX or an entity like it were to have been located in one of the other jurisdictions which now have that regulatory framework, would it have been able to be caught? And it seems as if, and correct me if I'm wrong, the answer is definitely no, for two reasons. One, it's not treated in the way like a security would be in other jurisdictions, where it would be subject to rigorous disclosure and audit requirements. That's the first thing. And then the second thing, I guess, when you mentioned that consultants had to be called in, the question is, do the domestic financial services oversight bodies, do they have the skill set in-house in order to understand really what's going on, far less impose or enforce any governance requirement?
Well, I think that's a very broad question, and I
Yeah.
think um, I'll answer it this way.
Yeah.
Because crypto doesn't necessarily display all the features of a security.
Yeah.
There's often the desire, the market desire to not have a heavy hand in regulation. So, for example, if we cast our mind back to there was a report from IOSCO, which it's called the Investor Education on Crypto Assets, and that was published on the 23rd of December 2020. They identify and IOSCO is the general securities body. They identify risks within the crypto asset market, being market liquidity, volatility, partial or total loss of the invested amount, insufficient information disclosure, and fraud. And their way of seeing a resolution or solution to that would be for member states to develop educational content, inform the public about unlicensed or fraudulent firms, to use a variety of communication channels, etc. But that is all broad. It doesn't make granular recommendations as to how to achieve consumer protection. And I think it goes back to an almost primal how do you regulate human nature, really? The wish to get rich quick, balanced against the risk or the need to protect one's financial interests. And I think more to your point about the capacity of Caribbean regulators, I do think there's capacity. However, even on a good day, onshore regulators aren't able to necessarily have a microscope to the activities of large crypto asset exchange platforms. So take, for instance, Binance. Binance is a Cayman domiciled exchange. It's one of the world's largest. However, the FCA in the UK would have from time to time imposed withdrawal bans. In the United Kingdom, stop notices, required more information or other assurances to be given as a regulatory response. That has been mirrored in Cayman. That has been mirrored in St. Vincent. That has been mirrored in, if memory serves, the BVI, where the regulators in each of those islands, upon a complaint, a substantiated complaint from a consumer client, have made changes or have made regulatory responses to the activity of a particular crypto exchange or a crypto trader. So I think that broadly, I think, answers your question in terms of capacity. I mean, there's always a need for more technical capacity, but really and truly, there isn't much that can be done, even in onshore jurisdictions, to control the actions of or the ramifications of a crypto exchange acting in a particular manner.
So I guess you can probably guess where I'm going with this. I mean, within recent memory alone, we've had 2016, the Panama Papers, 2017, the Paradise Papers, 2021, Pandora Papers. So the Caribbean as an offshore jurisdiction as a whole, I know that they're very different and independent jurisdictions, but in the mind of other geographies, they see it as one amorphous space. And the impact on reputation has been severe, has been incredibly severe. And one can argue that it doesn't show any signs of turning around itself, because even though, you know, I just noticed that in the press coverage of the FTX situation, and again, I don't want to cast aspersions because it's subject to review, and there's an independent investigation and so on going on. But there is a sense that things weren't quite correct, and as part of that reporting, they never failed to mention that he was in the Caribbean. And as if somehow being located in the Caribbean created a predisposition for irregularities. Why wasn't he onshore? He's American. His leadership team are all American. Why didn't they come onshore? They went to the Caribbean for a reason. And and it just seems, and some parts of the Caribbean have been damaged irreparably. I think, and again, I'm not casting aspersions, just anecdotally, of course, thinking of like Belize and Panama as a jurisdiction. Yes, you can create entities, but good luck in finding a reputable bank willing to deal with them. And that contagion is, I guess, as someone with an interest in the jurisdiction, it just seems to me cause for concern. And if it is, okay, so their regulation is relatively fresh on the books. And looking at it, we know, I mean, we don't know, but we can speculate that it has no teeth, in the sense that it would not prevent something like that from recurring. Then yeah, it doesn't look good. And when I was on a call yesterday, another one of these, and we were discussing other jurisdictions, and we note the ascent of the United Arab Emirates, and they had similar reputational challenges. They were on the blacklist. I think they're still maybe on a gray list, depending on which gray list you're looking at.
I think they're on the UP gray list, I think.
But they seem to be taking decisive steps to turn it around. The oversight, even in the free zones, there's some reporting required all of a sudden, whereas historically there wasn't.
That 9%, the 9% corporate tax, I think. Yeah.
The 9% corporate means that they're playing ball. They're listening to what they're being told by OECD countries. And banking, because it's like a pairing, right? Like wine and your meal, you need to pair them together. And entity formation and banking inextricably linked. I'm sorry. And I note that the UAE banks they're perhaps overreacting, but they are trying hard to get their act together and to be, more mindful of the type of clients they're onboarding and so on. Now, that stands in sharp contrast, and I'm sorry to draw the comparison, but I do think it's relevant. It stands in sharp contrast to what's going on in the Caribbean. There's been reputational slippage over the past few years. And then in tandem with that, we've seen press coverage of the exodus of banks, at least from the English-speaking Caribbean, which is what we're talking about. So mainly Canadian banks. Scotiabank, Commerce, Royal Bank, they are heading in the opposite direction. Rather than investing in woods, they are packing up shop, doing fire sales, and they're running for the hills. So yes, there's regulation. And so I've said all that, there's context, right? So yes, there's regulation, but I don't mean to be too contentious, but how useful would this regulation be if the intent is to nurture and grow a struggling offshore financial services center?
Well, I think firstly, and maybe putting my pride aside as a Caribbean practitioner, I would agree there has been some reputational slippage. But what I don't agree is with the legal arbitrage that has arisen. I've been in practice now 10 years. And what I can see comparatively between offshore and onshore is that the Caribbean is really a well-regulated and well-run set of jurisdictions. So take, for example, the BVI. The BVI has the BOSS system, or the beneficial ownership search system, which is disclosable only to authorized persons. And that sort of thing is replicated throughout the Eastern Caribbean. In St. Vincent in particular, you are not able to get information on the beneficial ownership of companies unless that information is requested either by court order or by an authorized law enforcement authority. So we have moved away from being the traditional secrecy jurisdictions to one of, I would say, benevolent privacy. And I think that is a fact that is not trumpeted more. A lot of these assumptions and a lot of these what I would term aspersions against Caribbean jurisdictions are not grounded in much fact. What it is grounded in is feeling. This is very emotive to say, oh, a billionaire is using a Caribbean jurisdiction to stash money away, and that's taking money away from hospitals and the rebuilding of roads and the feeding of small children in remote parts of an onshore country. Sympathetic as that argument may be, it's not borne out on the facts. And the many different more esteemed practitioners than I am, especially there's a chap in the BVI who's of Canadian extraction, and he has for the past, I think, 20 years or so, I've been following his writings. He has been consistent in demonstrating that the drum that most of these NGOs are banging is simply hollow. And it is hollow because of the type of regulation and the type of capacity that exists on island. And that is something that is demonstrated in CFATF reports, FATF reports, OECD reports. But conversely, the EU doesn't seem to have that position, and the EU COG seems to have a position that is purely political as opposed to empirical. And to come home to the crypto point, the failings of a particular exchange as a result of the actions or the nefarious actions of a set of individuals, fraud is fraud. That is individual responsibility. That is the misuse of the corporate form. That is a deliberate crime. Now, you may say, well, why the Caribbean as opposed to elsewhere? But that's not an empirical answer in my view, because in the Caribbean, you have had maybe, what, 2 or 3 crypto exchanges failing versus crypto exchanges failing in the US, in the UK, elsewhere in the Commonwealth world.
Like Singapore, yeah.
Yeah, I mean, financial failure is not something that is unique to the Caribbean. Financial fraud is not something that is unique to the Caribbean. What seems to be unique is the type of press coverage. What seems to be unique is the lack of a thorough investigative approach. And what seems to be unique is the description of the investigations and the outcome of those investigations by leading newspapers and leading commentators. Look, let's be frank. You come to the Caribbean because you want light touch regulation, you want the benefit of the climate and the location, and you want that cool factor. There's a reason why you come to the Caribbean has been at the center of international finance and commerce since the days of slavery. That's how the check got its popularity, the bill of sale, Lloyd's of London, that's how they all got their popularity through the use of the Caribbean. So we're not a newcomer to international finance, but what we have been known for is the ability to stick to the rule of law, and that rankles certain I would say I would say left wing, but this is the political show. But it disturbs certain sectors of non-Caribbean society.
Okay, fair enough, fair point. So we are where we are, and even though the actual, the actual management and control of these entities, well, the FTX was kind of like an exception. They tend to be elsewhere. The structures do take advantage of what you've said, what the Caribbean has to offer, that light touch, and that has its pros and that has its cons.
Indeed.
So we have this regulation, and it will do what it does, which will continue the philosophy of being light touch as we go forward.
And I think let's take the view that legislation is not fixed in stone. So, I mean, look, the BVI has circulated a draft bill. It's now for industry to comment on that, and then to have a finalized version which will be brought into effect. The AML set of laws have already been amended as of December 2022. Now let's look at St. Kitts and Nevis. They passed their Virtual Assets Act and brought it into effect in 2020, but they have already amended that twice. All right, the last time being 2021, and that was to streamline what are virtual assets. So what are the reporting requirements for a virtual asset service provider in respect of AML CFT, because it wasn't clear. So this legislation is not set in stone, and I think that it's a testament to our legislative responses. I mean, I would critique most of the Caribbean as being slow in terms of legislative responses, but the point being that there is a response that can be made where there is risk. And that's why the FATF has labeled any legislative response to be risk-based. Now, naturally, as a result of FTX, that risk is now going to be heightened. But that is why every 2 years or so, there's a round of evaluations by the FATF, whereby the local authorities for each island are evaluated and can raise or lower legislative responses if necessary. Okay. So there are a range of things that can be done and will be done in respect of the handling of crypto, or the treatment of crypto assets. Crypto, I think, as we've spoken privately, crypto is a leveler at the legislative level and even at the practitioner level, because it's something completely new. It resembles the old in that the indicia of what it means to be property, what it means to be property, how can it be held, is it a solid, is it a gas, that kind of thing. But the common law, the strength of the common law has shown through, and there are a wide range of things that one can do as an individual, either at the regulatory level or at the litigation level if you want a remedy.
So I have a question that follows from that. Each of these jurisdictions in question have approached it in their own way. So what distinguishes one jurisdiction from another? So for example, if someone is an entrepreneur or a trader, or they want to set up an exchange or whatever it may be, why should they choose one jurisdiction over the other? So for example, in Dubai, in the Emirates, all in, you probably have like 45 free zones, but you know that certain free zones are good for this. If I wanted to set up this type of project, this is the free zone I need to go to. If I want this type of structure, I need to go to the other, and so on and so forth. Is there any such distinction within these Caribbean jurisdictions?
I would think not really, and I explain why. So, for example, the distinction would come from not necessarily legislative response, because the laws are broadly identical anyway. Cayman, BVI, the model Eastern Caribbean Central Bank bill, they all have a common definition of what a digital what a virtual asset is, being a digital representation of value that can be digitally traded or transfers and can be used for payment or investment purposes, but does not include digital representation of fiat currencies or a digital record of a credit against a financial institute of fiat currency. So that excludes CBDCs. So for example, in the Eastern Caribbean, you have Dcash, which is digital cash, which is a digital representation of the Eastern Caribbean dollar. Or in the Bahamas, you have the sand dollar, and so on and so forth. So broadly, they have the same definition. They cover the same things. So virtual asset service provider, VASP, that's a common acronym between Cayman and the BVI. And it's a VAA, I think, virtual asset VAP, I think, in the Eastern Caribbean. So they're broadly similar. So the differences come in terms of what exactly is the aim of the person who is setting up a virtual asset service provider. So for example, Cayman and BVI, you initially brand name value. So Cayman and BVI have the largest amount of ancillary support services in the Caribbean offshore world. Cayman, you have the big 6 or so big firms that also span Bermuda, London, Singapore, Hong Kong, and the BVI themselves. So you have the big law firms and the brand name value of Cayman and BVI. But if you're looking to be more off the books, or let me not say off the books, see that I already said fraud, but off the beaten path, you have the more, I would say, the more gem-like or the more pearl-like jurisdictions, St. Vincent, St. Kitts and Nevis, that are smaller. You tend to find more traders. You tend to find much more traders in these jurisdictions as opposed to crypto exchange platforms, which are bigger and would require naturally something of a more brand name. So I think that's a central difference. As to the effect of the regulation, what I've noticed is that Nevis in particular, Nevis has a very high fee. I think it's something like 55,000 Eastern Caribbean dollars for the application fee, and like 100 and something thousand for the license. St. Vincent has not yet commenced its application of the Virtual Assets Act, so we don't really know what the application fees are like. Antigua is roughly the same. So it's roughly about, maybe, what's that conversion like? About 25,000? What, 25,000 US? So less than, what's Bitcoin at now? That's like 1.5 Bitcoins for the application fee, and maybe roughly about 9 Bitcoins for an annual license. So, it's not that unmanageable for a successful trader, depending on the market being notwithstanding its volatility. But there are opportunities for the discerning trader. And of course, consumer protection. What a big aspect of the regulation is about consumer protection. And you could only get your license under the Act if you provide a prospectus, details of dispute resolution mechanisms, and of course, there's also a statutory bond. So in the Eastern Caribbean, there's also a statutory bond. So in the event that the trader or the corporate entity goes bust, there's at least some money available to go out in a liquidation. So the state isn't left high and dry, so to speak. So, for example, in St. Vincent, that statutory bond is 100,000 Eastern Caribbean dollars, which is about 50,000 US. So that's just held in escrow by the state, and you get that back when you wind up your business. So there are a range of things that the legislation provides for, which I think are a useful response to the more shady side of the crypto asset world. So maybe let's just signpost and say the treatment of crypto assets in the Eastern Caribbean and the broader Caribbean is that, well, it's recognized, it's regulated, and it's used. And it's a matter of an individual taking legal advice, which would be tailored to their particular instances to understand the pros and cons for them.
Okay, all fair and good. This perfection doesn't exist. There's no situation that is perfect anywhere, but at least concrete and decisive steps have been taken and continue to be taken, because, as you said, it's not static. So
Indeed.
Steps continue to be taken to provide the protection and regulation that is obviously quite needed.
I think maybe going back to our earlier point on amendments to the laws, what I think industry is looking at least for two clients who have advised, the European Union is coming out with markets and crypto assets regulation, MiCA, and they've published a lot of documentation on that. And just to show the parallel between the EU and the Caribbean at the moment, now MiCA defines a crypto asset as a digital representation of value or rights which may be transferred and stored electronically using distributed ledger technology or similar technology. Now that's almost parallel to what the Eastern Caribbean Central Bank's model legislation has. That's almost parallel to what the draft BVI legislation is, and it's almost identical to what the Cayman law is. So what I think EU regulation and EU case law are really going to be looked at, because there's more volume in the EU, to be frank. There are more people in Luxembourg and Estonia, France, Switzerland, etc., who actually interface more with crypto than in the Caribbean, by my count at least. So that sort of regulation and the regulatory responses to that particular set of affairs, I think is going to impact on any likely amendment to practice and or procedure in the Eastern Caribbean.
Okay, all good. I think these are all good, but my original concerns remain about the reputational risk, and especially in light of what happened recently. I know that obviously, as you pointed out, other jurisdictions have had other controversies as well, but somehow, because of the unique history of the Caribbean, things are being painted in a different way, and hopefully this would mark the beginning of a step change, but we'll see. I'm looking for any questions, and I'm not seeing any questions either here or on Facebook. So
anything on LinkedIn?
No, nothing on LinkedIn either. So any parting remarks as we wrap up?
I think apart from fraud, the biggest area of concern would be insolvency. And when an exchange collapses, what happens? So, for example, the Cryptopia set of claims in New Zealand where New Zealand High Court, if memory serves, held that cryptocurrencies were property held on trust for the depositors and were not available for distribution to unsecured creditors generally. So there would be disputes there. But that has already been addressed in the Eastern Caribbean. And there's a case called, I think I would have written for HTJ tax in respect of this, the Philip Smith and Jason Cardaci, joint liquidators of Talk Group Holdings. And in that case, Justice Wallbank more or less held that crypto assets are to be considered as assets for the purposes of liquidation. Because when the exchange collapses, there isn't going to be much fiat. What's going to be, they're going to have a lot of wallets with public addresses that hold the proceeds, and those wallets could be accessed by private keys. So what Justice Wallbank held in that case, and that's at paragraph 30 to 32, and I'd read, now applying the analysis, and this is Justice Wallbank speaking, employed by the United Kingdom Judicial Task Force, this would indicate that the crypto assets in the user trading wallet are assets of the company within the estate. In giving this indication, it will be open to any stakeholder with an interest in the user trading wallets to seek to have this court come to an alternative conclusion. By contrast, the user personal wallets did not involve users transferring crypto assets to wallets that were controlled by or that belonged to the company. The provision of the user personal wallets was a separate service offered by the company to its users. The users utilize the company's platform as a hosting service, and the company would not have access to or knowledge of the private key, despite the private key being generated by the company's platform. I find it likely that the owners of the crypto assets within the personal user wallets is or are the individual users. So basically, what Justice Wallbank is saying, that look, this exchange, you have user trading and a user personal. What's in the user trading, that could be split up, used by the estate, insolvent estate. What's in the personal, because the company didn't have any direct knowledge of what was in there, that's to be out. So this demonstrates the ability of the Eastern Caribbean Supreme Court BVI division, and by analogy, because it's one court but with each circuit, but the judges rotate, and of course each of the member states and territories have access to the commercial division. What this demonstrates is that our courts, as a leading common law court, can give remedies in insolvency to those exchanges that may go bust, to individuals who may have issues with or that require remedies under the common law, to an exchange or against an exchange, or to a trader or against a trader. So I think apart from fraud, insolvency would be the big kahuna, so to speak, going forward over the next year or so. And finally, consumer protection. Now, in St. Vincent and the Grenadines, we've seen a lot of complaints against LLCs and IBCs, or BCs as they're now known, who engage in trading. And there isn't much recourse apart from getting a judgment against them in the High Court. But once the Virtual Assets Act comes on stream, or is commenced, because it's already passed, and those exchanges or traders are regulated because of the prospectus that they would have to give, and because of the statutory bond, etc., there is a greater chance of a remedy to a consumer of that entity. And I think those two latter, the insolvency and the consumer protection, I think those two things are going to be the great benefits as a result of the regulatory responses to crypto across the Eastern Caribbean and further in the Commonwealth Caribbean. But hey, take advice, take legal advice, and of course, take proper accounting and structuring advice from you know who. I wish all well. It's a new and exciting time in the common law world. And of course, it's thrown up some very curious accounting issues, especially in transfer pricing, etc. That I know I'll leave that in your capable hands, and I'll handle the legal work.
Mikhail, thank you very much for your candid and insightful exploration. What is it is controversial, it is topical, but it is necessary. Thank you very much. And thank you for those who have joined us on the various streaming platforms. We appreciate your time. Feel free to reach out to us at hcj.tax should you have any questions, comments, or ideas. Thank you very much. See you next time.
See you.